Now, let me talk a little bit about what sometimes are referred to as supplemental needs trusts and sometimes as special needs trusts. Um, One of my biggest messages to you is when you're talking about legal documents like a trust, and I told you about prices, it's really hard to say how much is it for X because a trust is not a trust is not a trust. And so if you say, how much is it for a trust? And you call around to 10 different firms, anybody that tells you a price with that much information must be selling you a commodity of some sort. But trusts are not a commodity. All trusts are not the same. They're a set of legal instructions that are written very specifically for whatever result it is that you're looking for. So we really want to make sure that we're thinking about what is it that we're protecting? What are we protecting it from? And what payments and to whom are we trying to make these payments? So whenever I think about a trust, I think of like a tube of toothpaste. Okay. So you set up this tube of toothpaste and you set up a set of rules and you fund the toothpaste is the assets or the money that you want to support someone with. The toothbrush is that person that you're taking care of. And then you're appointing someone to be the hand, your trustee, that squeezes the toothpaste out onto the toothbrush at whatever rate or for whatever things that you're trying to accomplish. And in the meantime, and this may be the most important part, you want the toothpaste inside the tube to remain protected from whatever it is we're concerned about. So when people say, I'm just going to leave a beneficiary on my account to my child or my disabled loved one, that'd be like squeezing all the toothpaste out onto the bathroom counter. Could they come by and swipe some? Sure. But it would also mean that it's available to everything else that's out there. Counting for government benefits, it's available to divorces, it's available to lawsuits, it's available to them spending it all, it's available to all sorts of things. So consider what it is that you are protecting it from and for. What are your goals? What are your concerns? And then what are the rules that we're trying to accomplish? A special needs trust or supplemental needs trust have very specific rules. The key language that are typically going to be in that trust is going to say, I want these assets to be used to supplement, but not supplant, impair, or diminish any forms of government or private support. And this is language that's been approved by Social Security, by Medicaid. If it's properly drafted, it will no longer count as an asset for that person. A first party special needs trust or a first party supplemental needs trust means that the money was that now disabled beneficiary or that now applicant for some form of government benefits. So maybe their grandmother left them a CD that went to them and it's going to get them kicked off all their benefits unless I do something with it. A first party special needs trust might be the right answer if an ABLE Act account isn't the right answer. Now, some key restrictions on that is they have to be under 65 in order to create this. It allows the trustee total discretion as long as it's not going to kick them off of whatever benefits they are to pay for anything the government benefits aren't able to pay for. But like the ABLE Act, a first party special needs trust is going to have to include a payback provision, which means if there's any money left when that person passes away, that money's got to go back to the state to the extent they've paid any benefits for them. Now, a third party trust, in my opinion, is the best way to leave money. If you're the person who's trying to take care of somebody else, the best thing you can do is prevent the assets that you have from ever becoming the person that you're trying to take care of's assets. Because once they do, our options are count them and lose whatever benefits they don't get anymore because they have that money, or move them into an ABLE Act or a first party trust that will then remove them from counting, but now we have to pay back the state with anything that's left. If you can prevent it from ever even getting that far by having in your own estate plan a third party trust where you say, at my death, I want to set aside $100,000 for Joey, and I want Susie in charge, and I want this money to be available to supplement, but not supplant, impair, or diminish any forms of government or private support Joey's getting. The trustee, Susie, still has the full ability to squeeze that toothpaste out onto their toothbrush. But now, if Joey unfortunately would pass and there's still $90,000 in that trust, I could say, and now I want that money to go to Joey's brother, Timmy, or to my nephew, Joan, or to my church. And there's not going to be a payback provision. Both trusts are going to have what we call a spendthrift provision, which means creditors and lawsuits can't attach to it, but not having to pay back with the money and being able to support somebody after that is a big benefit. So when you're comparing those things, ABLE Act, only persons disabled before age 26, soon to change to 46. If we add into ABLE Act first party trust, I would say the advantage on that who can use is if the disability occurred after that age limit, or the balance, which I'll get to, is too high, then I would go with a first party. But any person can have a third party trust. If they have a disability and you're leaving them money, even if they don't have a disability, you could set up a third party special needs trust. It just turns into a pure discretionary trust because they're not ever going to have their benefits affected if they aren't getting any benefits. And again, who's funding that? A person, if we're using their own money to fund the trust, then it's a first party trust or an ABLE Act. If we're using somebody else's money, then we're going to want to use a third party SNT. How many can someone have? ABLE Acts, they can only have one ABLE account. You could have more than one first party trust, although I'm not sure a good situation why I would. A third party trust, though, if mom and dad are divorced and they both want to take care of disabled child, they can both leave third party trusts in their estate planning. If grandma and grandpa or aunt and uncle or brother, sister, or best friends want to leave money, they can all do that without any sort of problem. Who can control the assets? You can name anybody in a trust to be in charge as trustee. On an ABLE Act, it has to be either the person themselves with the disability or their legal guardian, conservator, or an agent under a power of attorney. How much can you fund in a given year? An ABLE Act is going to be limited to $18,000. A first party special needs trust is unlimited, but you would have a payback provision, and a third party special needs trust is unlimited as well. And there's no payback provision on that. Again, ABLE Acts have a cap on how much can be put in, 100,000 for SSI, and total 550 is the current amount that you could put in there if you're not worried about SSI. And again, you could leave millions of dollars in a third party SNT if you want. There is no income tax on the ABLE Act account gains. A third party SNT, if there are gains and interest and dividends on those investments, they will be taxed at the trust level, unless they're actually distributed to the beneficiary, in which case you could tax it out at their tax rates. An ABLE Act is limited to only those qualified disability expenses as they lay out, whereas a supplemental needs trust, whether first party or third party, has no limitations except for if SSI or MoHealthNet or whatever benefit they're on says they can't pay for that or it's going to reduce their benefit. None of us are getting out of this alive. So everyone, if you have people or causes that you care about, then create an estate plan. Have a plan. Not because you're going to pass away or you just got to do it because you pass away. You're going to pass away someday. Because you have people that you're so worried about that you want to make sure you can tell them, if anything happens to me, you're taken care of. And generally, as a general rule, you're going to get what you pay for in the world. And so if something sounds too good to be true, or oh, my person said they got a trust set up for $200 through LegalZoom or whatever, you're generally getting what you pay for. And I wouldn't make cost be the only thing that's driving you when it comes to things that are this important. And especially when it comes to this type of planning, it's oftentimes true that you can more than make up the cost of planning by getting benefits you won't be able to get unless you do that planning. So try to think of it as a value as opposed to a cost, just a cost. It's a cost that you hope to have a cost benefit analysis where it's more valuable. One of the questions said something like, will a properly written trust interfere with receiving Medicaid? Um, the key is, what is properly written? What is the source of the money? Um, what are we trying to accomplish? Absolutely, we write trusts all day, every day that do not count against us for Medicaid. But you can't wait till you need Medicaid and then just unload $1 million and all of a sudden qualify for it. They thought about it. A lot of Medicaid benefits have a look back period. Excuse me. So if the assets are actually that person who's applying, we need some time. If it's your money that you don't want to get someone kicked off of Medicaid, absolutely make sure you have a properly drafted trust for your planning that can set up a trust within your trust that won't impact that person's Medicaid. So the key question that I think you have to ask is, do you feel like you've done everything that you can do so your loved one with a disability will have a comfortable life when you're no longer around? Again, I'm going to address one of the questions. Somebody said, if I have a special needs trust for my child, is this money for only after I die, or can my child use it while I'm alive? Well, unfortunately, I have to give you the lawyer answer again, in the sense that it depends. You can certainly set up a what we call a I'm sorry, a living uh third party special needs trust where you can set it up while you're alive. We'd have to consider what you're trying to accomplish. Are we trying to get money out of your estate for some reason? Do we have tax implications that wouldn't make sense? Is there some reason you couldn't support the person as you want to, when you want to, how you want to, just by writing a check out of your own bank account? Is there a reason we want to earmark it for them right now while you're alive? Certainly within your own estate plan, it's very, very, very easy to just have a great estate plan for you that also protects these people you're worried about. And then it wouldn't kick in until generally you pass away. But again, it depends what you're trying to accomplish. So a good estate plan, in my opinion, provides financial incentives for your heirs, helps them from blowing through their money, protects against divorce, provides disability protection, keeps your inheritance safe from creditors, con artists, lawsuits, and so much more, especially as it results or as it relates to um, disability protection and government benefits protection. So as the question, like I said, that is on everybody's mind is, what should you know about pricing when it comes to this stuff? Our firm, again, I was talking before to Sandy and Brianne, like, I can only speak for myself. I can't, I can't tell you what other people necessarily charge and how they do things, but we offer a no charge consultation. If you say, like, I came from St. Louis ARC presentation and I'd like to talk for these 60 to 90 minutes with an attorney, there is no charge for that meeting at all. And at the end of that meeting, what we would try to do is listen, ask good questions to get to the bottom of, again, if you came in saying, I want a guardianship, how much is it? I would probably say, well, let's talk first. What are we trying to accomplish? Who are we worried about? What are we talking about? Is that the right path? What are all these other circumstances we need to consider? And if guardianship is the right situation, then it will cost this many dollars. Sometimes with guardianships and some of these things, it's difficult because some of it has to be done on an hourly basis. Again, I, as best as possible, try not to, but some firms only work on hourly. I would try to work, excuse me, work with a firm that can say, here's what we'll do, here's what it'll cost, and the benefit outweighs whatever that cost is. And then trust whoever you're working with. The other thing to consider is some people think a trust is like a document that you sign and then all of a sudden everything you own is governed by that. No, a trust is like a box and it only governs assets that we actually titled to that box. And in some cases, we are setting up a separate box for this purpose, a separate box for that purpose, a separate box for that purpose. And you want to work with somebody who's going to help you decide which assets are you going to put into which box and why, from a tax standpoint, from a financial standpoint, from a legal standpoint, from a government benefit standpoint. A revocable living trust is a great thing I have for my family, and there's lots of great things that you can do to avoid probate in most cases, taxes, divorce, remarriage protection, income tax benefits. Um, but what you would probably need if we're worried about government benefits planning is some form of additional planning that goes along with that. Again, I can only speak for myself. So this is what our process would look like. Our process, I'm very visual. So I love that you guys are here. And I recommend everybody go out and learn what you can learn, listen to what you can listen, write down notes, ask questions, see what you feel good about. That's why I always tell people start with some sort of workshop or webinar like this and learn so that you know what questions to ask and can make the best use of your time, and think about it the right way. The next step that we do is that personal consultation and plan design. Like I said, it's about 60 to 90 minutes. My partner, Jackie Capriano, will kind of talk specifically about your personal and family situation. We have like a 3-page intake form we ask you to complete. If you have existing documents, we ask you to bring those in. And then, oops, shoot. And then we'll be able to recommend something from there. If we decide to work together, then we start what's called our asset inventory and funding, where we'll get all your statements and bank accounts and car titles and try to figure out how do we want to put this together from a tax perspective, from a planning perspective. What assets are we using for what purpose? And Rachel Dolan is our estate planning paralegal that handles that. And then I get together with you at that point, and I'll do what we call the risk assessment and asset alignment review. All right, how do we accomplish and how do we get as much benefit for you and the people you care about from a tax perspective, from a government benefits, from a cost perspective, and align your specific IRAs and 401ks and 529s and bank accounts and cars and house and whatever, to accomplish your objectives. And that meeting's with me. And then we sign everything and we'll get all the documents from Fidelity, Edward Jones, whatever the case may be, so that you have it fully funded when you come in and sign whatever documents you do with Lauren. And then I think the most important thing is having some form of lifetime communications and updates. I have some presentations I do where I show a picture of Robert Duvall from The Godfather and say, you know, you deserve a family consigliere, someone who can be your family attorney, and just somebody that as these things come up, you say, what the heck do I do? And then you get pointed in the right direction, or can just say, and you take care of it. Estate planning can be one of your most defining moments. How are you going to be remembered? Don't be remembered as somebody that leaves behind family disputes and court fees and taxes, because it's really, really easy for you to go ahead and leave behind planning that works, and your memory is a good steward. So take the time to do this, because as I said in the beginning, whatever is most important to you needs to be covered in your plan. And for many people that come to us from other firms or that haven't done planning, the things that are most important to them are not even remotely covered in their plan yet. And that's something that you can leave as a legacy to your family. So with that, I wanted to leave plenty of time for questions. I still have a couple on my list. Sandy, do you want me to hit those, or how would you like to go forward?
Yeah, one thing, thanks, Paul. It was so great. You covered so many things.
Mhm.
one that I just wanted to hit on since we were just kind of wrapping up kind of some of the cost stuff, which, I know
Yeah,
we did talk about earlier. Um, one person did kind of ask about, the ballpark, range,
right.
that kind of stuff. And you were kind of leading in that direction. And I don't know if you do want to throw that out just from, all your time in this field. I don't know if that's, something that you even want to try to attempt to do, or you want
Yeah,
to
I mean,
say, we don't really want to talk about that kind of stuff, or
I can
how you feel
try.
about
I
that?
mean, like, yeah, so generally speaking, I would say, um, kind of our low end planning, I would guess about, I would say for like a family estate plan, um, not using trusts and things like that, I would start at 2,900. The most common, like what I have for my family that can address all of your money, your estate, your powers of attorney, how you leave money for the benefit of someone, all those types of things, is more like 4,900 right now is kind of where we aim. And then if you're doing like super advanced, like um asset protection, tax avoidance, um type planning, it could certainly go up from there. Most of the times, like these first party, third party trusts that we build within are going to be part of your general estate plan that we can, for the most part, get in there for that range. Again, guardianships are so much harder. I can just tell you it's going to be like a few $1,000s because we do kind of have to do that hourly at like 400 bucks an hour, and plus paralegal time, court time. I mean, it depends how long and how much fighting and whatever else there might be. There's a guardian ad litem appointed by the court. There's all sorts of kind of harder things
Right.
to judge. um but if you can fix it with paper privately without having to go to court, in the long run that will be far more advantageous, far less expensive. um but I hope that kind of gives like a range, kind of at least an idea. um and again, all that roadmap of stuff that I was talking about, we don't charge hourly if we can define it in that scope of like, all right, we're going to do a revocable living trust that's going to protect your minor children, your kids with disabilities or special needs or government benefits. We're going to do powers of attorney for both of you. Any kids that are 18 to 30, powers of attorney for them. We'll do your deed. We'll do all that stuff, and it's $4,900. Then there's not any hourly billing for any of that, for any of the meetings, for any of the phone calls. As long as you're an attorney or a client of our firm, that's gonna be included.
One of the families asked, is there a way to kind of, set up a payment plan, or is this something that, you would kind of want to pay all up front, or anything like that?
Yeah, we generally do it over the course of like 6 weeks or whatever. I mean, generally it's going to fall into different. We don't do it all up front. We usually have retention, some
Mhm.
sort of down payment, and then kind of go from there. I mean, ideally we're doing like half at the beginning and half once everything is like completed, or like, contractors might like at this 30-day mark or do that. But um yeah, I mean that's generally the answer. And again, we can usually figure stuff out.
I have had this question before in another one of our webinars, but this is a great one. So this is about moving out of state. So if you set up your trust or your Able account or stable account right here in Missouri, and then you move out of state, kind of what happens? So specifically, you move out of state, maybe to care for parents or something like that. Do the trust transfer? What about the Able account as well? How does that work?
Yeah, great question. So as for the trust, that's much more common. So let's start there. So all these things are state law, and drafted as such for a resident of Missouri or Illinois or wherever you're from. That having been said, they don't become void when you go to another state. It just might not be as ideal when you go to another state. So here's what I do and what our firm does. So we're, as part of the American Academy of Estate Planning Attorneys. This is not just a group that, like, if you and your business like join a group and you pay fees to say like, I can put this emblem on my account now or whatever. Like, these are attorneys that I know nationwide hundreds of firms in every state that will use similar like document software, education, um, structure as I have. There are people I know. I'm leaving actually a week from today to go to San Diego for a conference where I'll see all of them. So most of the time, if people say like I'm moving to Florida permanently, I have so many clients I can't even describe to you that I hand off depending on where you are to this firm who knows what they're doing, that does what we do. And it's not like you got to start over. When someone comes to St. Louis from somewhere else, and I know they came from someone like that, I tweak it. Obviously, if we have to apply for Missouri Medicaid, you are receiving Massachusetts Medicaid or something, it's going to be a different application. We got to do some things, but it's not necessarily starting over. But I wouldn't
Right.
move and not address that if you have recently moved.
I think that's great. And a lot of the, like you said, a lot of the legwork's kind of done. So I think that's great.
Exactly. And also the relationship is there. And again, I could
Right.
call that attorney with you and say, hey, they're moving down here, our clients. This is where they're at right now. They're going to need to transition here. How do we
Sure.
do this? And you're not alone, you know?
We've got a couple questions that are specific, but I think they could apply definitely to some families. So one is about, there's some parents who had set up guardianship for their child, but what if they happen to go through a divorce and they were co-guardians when they set it up? And then what if one parent wanted to be the only guardian? Is that like what would that process look like? And we know we work with a lot of young adults who they're young adults with IDD, and we talk to them a lot about they have guardianship, and they talk about how sometimes that happens, and their parents who are divorced are um, arguing or fighting, or they're very transparent with us sometimes. And um yeah, that's a tough situation. We hear about that sometimes. So any
Yeah.
advice?
Yeah, it is. And then the main advice I would give you is it should be dealt with in the family court.
Yeah.
So a lot of times family court and probate court, because probate technically deals with adult guardianships and conservatorships. However, when there is a divorce and there is a guardianship of a young adult that is involved, that needs to be addressed in that divorce, just like a parenting plan of a minor child or whatever else. And a lot of time, I can tell you both courts are charged with acting in the best interests of that adult child. And so it should be resolved. There should be an addendum to the guardianship based on what is decided on that. It may be that co-guardian still works. It's just that guardian has them these days, this guardian has days. But don't think that they're two separate they're two separate issues. They're really not. And there is coordination between, like, if I have done the guardianship in the probate court and you're now in family court with this judge and this attorney, you'll want to coordinate the two courts and the two attorneys while that's going on to make sure that it's all figured out. I unfortunately had one case, family law attorney called us last week, um, and they were handling a conservatorship of um of an adult child who parents died, and there was who were the legal guardians, and there was a personal injury case going on because they didn't die right away, or one of them hadn't passed away right away, but there was a personal injury case on behalf of that person, and then that person died and they had to substitute guardians, but they didn't have, and the court, the conservatorship court said you need to open a conservatorship for this potential claim. Well, the personal injury attorney didn't substitute that new conservator as a party to that personal injury claim, and the judge in the personal injury wrongful death claim threw out the claim. And now that disabled adult child who's lost their parents now also doesn't have this potential money because procedure wasn't being coordinated between everybody. And that was a big issue. And it's because no, but they're like, I didn't know that I had to do that. Well,
Right,
like
right.
the family law attorneys aren't going to know that part. The PI attorney's not going to know that. You got to really
Yeah.
coordinate all that stuff.
a couple of people have kind of asked this in a pre-submitted question, and I think somebody asked this in here too, kind of like, what if we don't have anybody that can
Yeah.
be our trustee? What if we don't have a family member, a loved one, a friend? What do we do? Like,
Yeah.
goodness, I mean,
Yeah.
that's tough.
It's really hard. I mean, I've got thousands of clients in the St. Louis area, so we've come across this. And my advice is generally sometimes there's the best person, sometimes there's just better than anyone else or better than the worst. And one of the questions that was pre-submitted is what if there's no one to be trustee and also not much in the estate? What can we do? Because obviously I could say, well, there's third-party trustees, corporate trustees. There aren't as many corporations that want to pull your plug, so to speak, or be a healthcare power of attorney or agent. Most people would be your trustee for a fee. We do have some corporate trustees that'll serve for what I think is relatively inexpensively, like 400 bucks a month, 500 bucks a month, which, a few $1,000s a year. How much is like too expensive? If we're talking like less than $100,000, well, if that $100,000 you can either get your loved one kicked off government benefits or not, I would spend a few $1,000s to keep that $100,000 and all of their health insurance and their monthly income and their whatever. If you have a friend or a family member who will do it for free, even better. Or, sometimes we'll serve in that role as a very last resort. And again, we are anytime it's uneconomic for you, it would be uneconomic for us too. So like we would try to figure out what would be the best solution where like, okay, here's what we could do it for, and I see that the benefit outweighs the cost, or let's talk about this person, this company. And it's something we work through. Again, don't let the fear of like all these what ifs stop you from
Yeah.
taking the first step. Let us run into that problem when you get to it and try to find the best solution is what I would say.
There's another really great question about, and again, I think this was addressed in a previous special needs trust webinar that we had, but I cannot remember. But this is about if you have multiple children, if you have one child that might have IDD, a
Mhm.
disability, and you have other children that do not. How does it work? Do you have just one kind of family trust? Do you have individual trusts?
Usually for us, it would all be one big plan, one same cost. We would just set within the Paul Gantner and Sally Gantner Revocable Living Trust. And let's say Lewis is my son with IDD and Olivia and Audrey. No, I would still split one third, one third, one third. But for the other two, maybe I would say if there's not a compelling reason not to give it to them, they could just take their full one third. But for Lewis's share, I would say hold it in this supplemental needs trust with Audrey in charge. And it's all one plan, all one set of documents. Now, when you die, it requires some administering each third and setting up the separate share. But it's the setup is that's actually relatively standard of a setup
Mhm.
to make sure everything's protected for
So
that
you
one.
can have everything in one, but you can kind of have some real detailed specifics written into it. So,
Oh, for sure. You can
depending
tailor it to,
on,
and
yeah.
yeah, to exactly their situation. Or maybe one kid we just want to give 5% a year, and one kid we want to send it over
Yeah.
10 years, and one.
Because
I mean,
you know those personalities, right?
oh, yeah, exactly. I
Yeah.
have three.
That
All three are.
firstborn's real responsible,
She's
and
fine.
you can give them all to them at 18. Maybe one has to wait till they're 30, right?
Yeah, exactly. Three kids, all very, very different
That's
for
right.
sure.
That's right.
And yeah, so again, that the developmental disability type stuff, that's just like any other thing that makes your kid unique from the other kids in
Sure.
your family or anything else. And
Sure.
so it's not a huge issue. Another thing that kind of relates to that I kind of want to mention too is like, can the trust, we talked about Medicaid. Yes, of course. Can it be used for living expenses if Medicaid can't, won't because things are, yes, like it's supplement, it's for that. That's the purpose. And somebody else mentioned a question that was like, is it still possible to receive Medicaid when Social Security, not SSI, is much greater than will allow? One of the things I want to point out is like, as I mentioned, there are many Medicaid programs. And so when people say my income's too high for Medicaid, what Medicaid are you talking about? And maybe it is, maybe it isn't. And even if it is, there's special kind of trust. I'll just say the terms qualified income trust, or sometimes they're referred to as Miller trusts, are meant to reduce your income basically on paper to qualify for benefits and still use those assets for qualified expenses. Those that extra income can just be set aside and still get your government benefits and still use that money to protect that. It's just a matter of like coordinating. All right, what kind of Social Security are they? Say Social Security, not SSI. So it's not supplemental security income, which is typically someone who's disabled prior to 18, never had any work quarters, but also their parent, they don't have a parent or a spouse or anybody else that they would qualify under their work quarters. It's possible you could get SSDI and never have worked and been disabled as a child under your parents or a spouse's record, but they have to be retired or disabled themselves before we can kick those things. Those wouldn't have income and asset limitations, and the amounts would be all different. And so again, it's kind of hard to give like this is always the right answer, this isn't. But sometimes we have two parents, one was disabled, or two parents divorced, have an adult disabled child, and the one dies, so they start getting survivor benefits off that kid and then off that parent, and then the other parent retires. We could potentially get retirement disability benefits there. You can really start stacking things. And then for health insurance, if you're on SSDI, you might be receiving Medicare, and typically there's a 24-month wait for that. Or you might be eligible for Medicaid, or you might have too much assets for Medicaid, but we can use like a parent's dependent health insurance to get through that 24 months and then be way better off with Medicare. But it's just so much. Like I could Google and YouTube, how to fix the plumbing in my house, right? Like, or even like the starter on my car. But why? Like, there's so many people out there that do it way better than me that can come out, like, just delegate some of that stuff is what I would think.
And then there's one about you all helping kind of access SSI benefits. Sometimes this person's understanding is that that can often require legal help. And I will say that our agency does have a family support team that can kind of help fill out applications, support you with that kind of stuff, make phone calls with you, get you in touch with some right people. But if you are having some real specific kind of struggle with that, yeah, maybe it does require more help.
Yeah, and our firm actually doesn't specifically do the SSI applications. We have firms that we recommend that have done great jobs for clients in the past. We kind of are the same way, that we kind of coordinate when those benefits are obtained. We do Medicaid and veterans benefits, but Social Security is kind of its own administrative stuff. So, but from what I understand, generally speaking, yeah, like the vast majority of SSI applications get rejected upfront.
Yep.
But the way the system is set up is to reject you and then hire an attorney, and then the vast majority of those get overturned. And whether that's great, awesome, I would say probably not, but don't give up. Go through the process. We can help you determine if you should qualify, and then get you to somebody who can walk through that if you can't submit it. But a lot of times I think even those firms will tell you submit on your own up first, because the appeal is kind of the place they're going to win and your best use of money and time of an attorney.
And one of the last ones is someone saying that they really like that you have the social workers on staff and that they haven't heard that at any other law firm. I have not heard that either. So that is really great and impressive. Most of the staff that works here come from that background. So of
Oh
course
yeah.
we're all about social workers. They want to know kind of how do those social workers assist with the different things that you all do, the estate plan and the guardianship, and also do you all take on MSW students for practicums and things like that? So I don't know,
Yeah.
maybe they've got somebody in their household that needs a practicum position. We do
So we
here
have
if
an
you do. St. Louis Arc takes
Yeah,
practicum students all the time, so.
great. We have one currently actually as well. The answer is yeah. So we have one MSW practicum that we've kind of helped. She works in her case, works full time. Finished that studying, took the tests, and we've got kind of the practicums mentoring, different sessions she does kind of along with her day-to-day stuff. We have an LCSW, we have a GCM, so geriatric care manager, licensed clinical social worker. They help with placement a lot of times. They help with the Medicaid applications and government benefit applications. Like I said, even my own mom, like I deal with all the taxes, the trusts, all the legal stuff, the financial stuff. But when she had a fall or has a medical event and we're looking at rehab facilities or get my medical devices from here or what home care you use, like I relied on them so much because they just have
Oh
so
my
much.
goodness.
So I bring them into almost every one of these consultations to introduce because there's going to be more questions that are more their wheelhouse than
Yeah.
mine. So
Mhm.
yeah, everybody's going through a lot. If they're in our office or any office like ours, they're going through a lot. And it takes a village for sure for any of us to get through this life we live. So um I love to do it, and I'm lucky to have a good team there. Like I said, that's another thing I would say when you're working with any team, like if you're one lawyer with a stack of stuff on your desk and voicemails you can't get to and phones that can't get answered, you're not going to be able to do this type of work. Again, I appreciate the opportunity to speak with all of you today, and Brianne and Sandy, thank you for everything. Logan, thank you for helping coordinate where I need to be and when. That's always a big help. And if we can help anybody, please feel free to reach out, either through the ARC or directly through our office. Again, Jackie Capriano usually would take that first meeting. And again, it's just because that's where she is the best. And I would meet with you along the way. It's our whole team, and just let them know where you came from so you can take advantage of that.
Have a great evening, everyone. Thank you again so much for spending your time with us. We really do appreciate it. Thank you so
All right.
much.
Bye.
Bye-bye.
Thanks, guys.